Okay, everyone. I apologize for the delay in posting this video, but this actually is truly the first chance I got to record it. Well, today we'll be basically continuing on the difference between performance and design specifications, and we basically just want to have a quick review of the main differences between a performance and a design specification, and kind of a quick overview of what we covered so far in this particular lecture before we go into the specific case that we see in front of us right now. So just as a quick overview, design specifications are also known as materials and method specifications, and what they do is that they state precise measurements and tolerances for materials, methods and sequences, and the quality of work to be performed. They talk about inspection requirements and so on. They basically spell out in detail how the contractor is to build something. They basically provide details of the materials that have to be performed, furnished, and how the work is to be performed. Performance specifications, on the other hand, they just state performance characteristics required, and as long as the performance is met, the design measurements of how it's been performed doesn't really matter. And in this case, the contractor does accept responsibilities. We also mentioned there's a third type, which is a purchase description specification, but it's not really relevant to the cases that we're talking about. Of course, it's important to us, so you have to still know it. But last time we did cover quickly, actually took some time actually covering a case that's called the Frun-Kalnen Corporation versus Niagara Frontier Transportation Authority. And remember, it was a contract for building 2 tunnels. There was a performance specification that required that the tunnels be airtight, to be watertight. However, the requirement was, and basically, of course, it leaked, and that's the cause for the dispute. The owner argued that it's a performance specification, and the contractor carries the responsibility. The contractor basically argued that it was actually a design specification. The court did view that, like looking in overall situation of the contract, that it basically could be perceived as a design specification, and there were many reasons that we mentioned why the court, when looking at the contract as a whole and the dealings between the parties as a whole, found that the specification, although written as a performance specification, is actually a design specification. Okay, now let's move on to another case that basically is relevant to the issue of design versus performance specifications, and this is the case of Blake Construction versus the United States. It's basically a case specifically against the U.S. Navy, and it's basically a case where there was a naval base that's being constructed, and they basically they had drawings that indicated that there would be overhead electric conduits, but there was a note that stated that the contractor is allowed to relocate those conduits in order for them to coordinate with other trades. So in this case, if you have congestion on the overhead area, like for example, if you have interferences with for example pipes, or with other mechanical trades, such as for example ducts and stuff like that, people who are doing duct work. In this case, the contractor is allowed to relocate the conduits such that they basically can allow for the other trades also, so as to basically minimize the conflict. So when the contractor saw that, they thought that they had full leverage, and they basically decided that they are gonna go ahead and put the conduits underground instead of putting them overhead. And this basically led the Navy to ask for them to be specifically installed overhead instead of just putting them down underground. Blake did comply with the request, but however, they made the claim for something called a constructive change order. So what a constructive change order is, and we'll see that in the future, is basically a change order that is not truly a change order. It's just a request that has been made by the owner that led to them effectively creating a change order. So this is what we call a constructive change order. And at the first level of litigation, the Federal Court of Claims agreed that Blake basically had the right to that amount that they claimed, and there's basically a constructive change order. And the Navy appealed and at the higher court, the Court of Appeals, they basically had their day also. They basically went and they presented their case. In that case, Blake did claim that the specifications were performance specification that did allow them to install underground, so they gave them full responsibility as long as the performance is met, and as long as the electric conduits are installed, and as long as that there are no conflicts with other trades. However, the court did not view that there was basically that much freedom in that performance specification. So the court said that although this design specification was defective and could really you can actually view it as basically a performance specification, it does not give the contractor full discretion. So kind of this kind of a rule that we can get from this case. So although so let's say for example you have a performance a design specification that has some major problem, and by virtue of your knowledge of the situation as a contractor, you can basically view it as a performance specification as a result of this defectiveness or infeasibility. So it's basically a design specification that's infeasible, but still that does not give you complete discretion in acting. The court also drew kind of a distinction between the performance and design specification, and they tried to say it's not really an absolute distinction. So there is no one specification that when viewed in a contract you could say that this is absolutely a performance specification or this is absolutely a design specification. So many specifications have a bit of both. So as a result of that, the court did view that the lower court, the Federal Court of Claims, the Federal Claim Courts, the Court of Appeals viewed that the lower court defined the amount of discretion given to Blake too broadly. So they basically tried to restrict that amount of discretion, and basically as a result of this, the court did view that one of the reasonable interpretations of the conflict of this particular case would actually avoid the conflict, but still would be for Blake to basically avoid the conflicts but still install it overhead. So basically the Navy basically had a right to insist for it to be installed overhead because this is what they required, and because of the indication that was made of that in the drawings. And then finally the court basically did just reverse the claims of the judgment of the lower court. So this is a case again where we have the question of whether a specification is a performance or design specification was key to how the court viewed the case. And in this case, strangely, the contractor wanted it to be performance specification because that gave them more leverage and gave them more ability to go ahead and build it the way they want, or at least for them to, in this case, to be able to claim for additional charges from the contractor, from the owner, because the owner is kind of creating a constructive change order in this case. Okay, so moving on, other documents that create are basically our sources of contract documents. Basically, some is what we call general and supplementary conditions, and general conditions are, as the name specifies, they're basically kind of guidelines that clearly and completely detail the rights and duties of each party. The supplementary conditions kind of supplement them, so the supplementary conditions are in addition to the general conditions. You can't have one and not have the other, and they often deal with the following subjects. So these subjects are usually the subjects that are covered by both types of specifications: scope of contract and resolution of conflicts between them. So basically, what we call precedence of documents. So the documents that have significance over the others, and if there's in case of for example ambiguity, which one has more precedence than the other. It talks about the role and responsibilities of the main principal party. So contractor has to do the work, owner has to basically pay the money, architect and engineer basically has the role of certifying that the work is done right, and so on and so forth. How to manage subcontractors and separate contractors. So again, the difference between a subcontractor and a separate contractor is that in some projects we have something called multiple prime contractors. So we have multiple general contractors, and the coordination between them is usually the owner's responsibility. In the case of a contractor having multiple subcontractors, it's the general contractor's responsibility to basically coordinate with their subs, and have their subs also cooperate with other separate contractors if needed. Talks about time, amount of time, commencement dates, end dates, the amount of time total, and so on so forth. Payments and completion. How do progress payments get made? What's the process of certifying completion of the project? Basically protection from risks and losses to persons and property. So it would talk about the requirements for insurance, who would be providing the insurance on the project, for the project itself, like the property that's included in the project itself, and also for third parties, like the liability type insurance that will be carried in order, for example, if someone gets injured, that insurance will cover them, or will cover the owner and the contractor in case someone gets injured, and they sue both of them as a result of this injury. So it does talk also about changes, the process for creating changes and proving them, corrections, if there are errors to be discovered and how they be corrected, the process of terminating a contractor. So in case of non-performance, in case of the default or breach of contract, how do they get terminated? What's the process? Dispute resolution, that's another topic. And we also have explicit talk of insurance. So other than basically talk about risks and loss of persons or property, we also have that. There's a major difference between general and supplementary conditions and something called the legal condition. The legal condition is, by definition, it's a construct, a legal classification, something that basically requires something to happen before the other. Sometimes we also we kind of refer to it as kind of a condition precedent. Sometimes we call it a condition precedent. So in order for something to happen, something else has to happen. In order for you to be able to do something else has to happen before. So in order for you to graduate, a condition precedent is that you pass my class. So that's a condition precedent. So that's kind of an example of it. I mean, hopefully everyone's gonna pass, but the kind of it's kind of something that we write in a contract in that form. Now the difference between that and general conditions is that general conditions of contract, as I mentioned, is kind of a contract document. It includes all the terms and the rights and duties of parties and all the stuff we talked about before, and they definitely would include legal conditions. They would definitely include conditions precedent for things to happen. And general conditions will be the subject of our next module of the class, and we'll spend a significant amount of time talking about them. By definition, they are standardized, prepared documents. They're forms, basically. So you take them, you go through. Sometimes you can edit them because now they're available in soft copies. You can edit them, change things in them. And they're usually authored by a major entity, such as, for example, the American Institute of Architects. There's another set of contract documents that were authored by the Engineers Joint Committee on Contract Documents, and also the International Federation of Engineering Councils, FIDIC. These are all examples of standard forms of contract. There are, of course, standard forms of contract in the United Kingdom by, for example, the Institute of Civil Engineers. ICE has a whole set of those, and basically the idea is they're being authored by those major entities, and the reason is that they're designed for use in multiple transactions. You find that a lot of the terms that you find there are common between many of the projects, and you find that they're possibly reusable. However, they sometimes need to be fixed and adjusted in order for you to take into consideration of local conditions and conditions that prevail in this specific project, and therefore we have supplemental conditions that supplement those general conditions and kind of describe what needs to be fixed in them in order for them to be exactly applicable to the project. So it talks about, for example, general. So as a result of that, supplemental conditions would talk about a bunch of topics. So, for example, they would talk about special conditions required for a particular contract. It would address the differences that or conflicts between the general conditions and statutes or local requirements. It would basically modify the general conditions as necessary. It would talk about, for example, things that, well, the point here, other things that could talk about, for example, is that if you want to modify, for example, the specific article of the general conditions, sometimes you go ahead and fix it or change the wording of it in supplemental conditions and consider the one that's in the general conditions to be invalid, or basically just cancel it out. So in many cases, if you go in and sign a contract that's AIA based, you've done 100 of those before. Sometimes that could give you as a contractor a false sense of security, because you basically have worked with this document before. What you may not know is that the supplemental conditions may have modified them beyond your recognition. So it may have modified them to the point that they're no longer that same set of conditions that you're used to, that you can work with, you've been working with. Basically, sometimes if you basically give precedence to supplemental conditions over general conditions, can actually have courts it allows them, it gives them room, or it facilitates for them, for courts or for judges to kind of reconcile conflicting language. The reason being is that if you give the supplemental conditions precedence, it means that you're very intentional and purposeful in changing the language of the general conditions. The best advice that many lawyers give is that you basically just should delete the clauses that are addressed by supplemental conditions from the general conditions. So if you have access to the soft copy and you can go ahead and delete those, just delete them in order for you to avoid duplication or avoid an article that will be present in both, and the question of basically reconciling any differences that they may have. I mean, that will be just avoided by having the writing in a single location, like either in the supplemental conditions or in the general conditions. Okay, another set of documents is the subsurface test reports. These sometimes are included in the invitation to bidder. These could include the specific piece of information, so it could be sometimes test report data, it could be site data, it could be basically references that the data is available somewhere at, for example, a specific geotech consultant that's been hired by the owner. In general, the legal effect of those will be discussed later, but in general, they usually are made less than effective, because there's usually a case. It is usually required. I mean, the contractors are usually required to go ahead and familiarize themselves with the job and basically carry that responsibility and place that responsibility upon them. An important rule that we need to discuss in this class is a rule that's called prior negotiations and parole of evidence, and basically this just talks about how admissible are negotiations or agreements prior to the writing of the contract. If we sit down and we discuss 100 terms and then we come back and write a contract for 50 of them, are the other 50 enforceable? That's the question that's addressed by this particular rule. So the parole of evidence rule states that a written agreement and all the documents that are included in a document by reference are basically the complete agreement of the parties. So basically, this is what we ended up agreeing upon. Anything that we discussed before or during the creation of this document they could be oral agreements. They are not really binding. The reason being is that the writing here kind of is the culmination of what we've been talking and thinking and arguing and discussing and negotiating about, and therefore we basically have come up and simmered it down into a set of written articles, and then anything before that could probably be just negotiations that didn't go through, and we basically don't have them enforced. Now this is actually sometimes even emphasized in contracts, and we see that in AIA and the other types of contracts that we're working with, that sometimes the contracts have something called an integration and merger clause, which states language along the lines that this written agreement is a final and complete agreement, and the existence of such a clause would make it hard, but not really impossible, to prove prior oral agreements. In general, proving prior oral agreements is not an impossibility, and it becomes easier, as I mentioned, if integration and merger clauses do not exist, and sometimes courts give themselves the right to consider circumstances and conversations if such disputes arise about prior agreements. Okay, now another important topic that we have, the final topic that we have in chapter 3 in lecture 3, talks about modifications, and basically it kind of tries to create a distinction between something called a modification and a change. Now, by just like linguistically, you're probably gonna say modification and change are just synonyms. They have the same exact meaning. They're not any different. However, legally they do have a difference, or at least in contract language or contract law language, they have a bit of a difference. First, changes, they can occur during the construction, during the execution of the project. They're usually governed by carefully drawn complete provisions. So it have a change management clause, a clause that talks specifically about change, that is very, very well drafted, and most general conditions of contract have very well written change clauses. The owner has the right to order changes, because you don't want to, as an owner, you don't want yourself working with a project and then discovering that, oops, we need something extra, we need something less. You don't want to be stuck in a situation where you can change the project and have it in the end constructed in a way that does not fit your purpose. So owners in almost in every general set of general conditions of contract are given the right to order changes, and the contractor has to comply. However, the contractor has to comply and perform them, not for free. They basically have compensation. They would receive compensation for those changes, and usually there is appropriate language handling that in the general conditions of contract, and we'll study that, as I mentioned, in detail, I promise you. Then another the thing that's again the difference, a different thing that we need to look at least legally, is something that we call a modification. A modification is a change that would be agreed upon by both parties, and it changes their basic obligations in the contract. And of course, as a result, it's not based on any contract provisions that exist, and it basically is in itself a contract and must meet the requirements for a contract to be created, which includes a certainty of terms, offer and acceptance, or basically mutual assent and consideration. And finally, there is a rule that's related to this, which is called the pre-existing duty rule. And I think we mentioned, I'm not sure if I talked about this before. I actually did talk about it with someone in office hours. In general, a rule does exist, and this is a rule that's held by courts, that says that a contractor can't really get a price increase without giving something in return. So you basically can't like have a contractor comes back and say, you know what, this building that I went into contract for building for $1 million, you know what, now I want it to be 1,100,000, and I'm not gonna change anything. I'm just gonna build you the same exact building. Now that, according to the pre-existing rule, this would not fly in court. The court would not approve such a thing. However, if the scope of the project changes in any way, even like by, for example, changing quality of what the product's gonna be in the end, quantities of specific things, if any of those things change, you basically can go ahead and claim that this is a new addition to the contract, and therefore it warrants a change in the compensation that you receive. So the pre-existing duty rule would cease to apply in this particular case. Okay, so this was lecture number 3. Let me go ahead and take a quick pause and come back and start recording lecture 4. Okay, everyone, so we're back. Now we're going to continue talking about other sources of rights and duties in construction contracts. And here we're going to actually start talking about the second objective, which is understanding something called judicially determined terms of construction contracts. Okay, so what are these? So sometimes the court finds itself forced to employ terms of construction contract. And this happens sometimes due to the following reasons. First, sometimes there would be matters that were not considered by the parties, and they may have been too obvious. Actually, there are matters that have been considered by the parties, but they were too obvious to state in the contract, so they don't have any statement about them in the contract. So the contract the court may need to imply those. So, for example, if it's for example known in practice that you always get paid at the beginning of the month, or you get paid every 2 weeks. This is something we didn't state in the contract, but this is just the custom, and we basically just didn't mention it because didn't make any mention of it. And sometimes the court may actually find it necessary to employ such a term. Second is that sometimes matters would have been discussed during a negotiation, but they're not resolved. So, for example, we decided to start work without finalizing our discussion about those final couple of items, and we just left them till later. So, in this case, which agreement would the court apply? The court would probably apply the agreement or create the agreement that that would have existed as a result of this negotiation, at least in the opinion of the court. The courts also may be asked to fill in gaps in matters that were going to be agreed upon later. So, for example, negotiations, they don't end, but sometimes we actually have an explicit agreement to agree. So remember when we said before, agreements to agree are not really enforceable, or the only way that it could be enforced is to have them have the people sit down and try to get into an agreement. But in general, what we're trying to say is that court may actually try to look at what would have been the result of this attempt to agree on those terms, and basically they would actually employ those terms. Sometimes the court would also be needing to fill in the gaps. It will be driven to do that mostly if it's convinced that the parties did intend to create an enforceable agreement, not just that they were trying they were discussing with each other the possibility of getting into a contract, and they never went through with it, and they never concluded it. Until recent years, courts actually were kind of reluctant because they saw themselves as enforcing contracts rather than creating them. But in more modern times, courts are more willing to make contracts, especially with the increased number of standard forms of contracts that came into existence, and the existence of contracts of adhesion. So sometimes if you have a standard form of contract that is entered into through adhesion, sometimes that makes it more of a compelling case for the court to start filling in terms. Filling in those gaps actually may need some negotiations. So basically, the idea is that you basically want to make sure that the gaps that are left are not really huge ones. So the idea is that you want to basically leave, when you're constructing a contract, you only leave very minor items that are not discussed or not agreed upon in the, so that courts would not find themselves trying to interpret entire contracts. They're just interpreting small pieces of that are absent from a specific contract. So if you have a negotiated contract that you're trying to talk about, and it's not a contract of adhesion, it's a contract that was entered into freely, you basically they fill in courts would basically fill in gaps where there's very small items left, not necessarily the entire agreement left for interpretation. Many courts are going to be less likely to employ terms if any express terms exist. So if there's something that fills the gap from within the contract, they basically are going to interpret those terms in a way that will basically create an implication or implies the gap. So if there's anything that's possible to fill the gap from within, even by way of interpretation, the gap will be filled from the contract itself. Now, that's not always the case. You may actually find that that's not even possible, but in general, so say they will go to other sources, the sources that we're going to talk about in just a moment, if they're unable to find anything to fill in the gap from within the contract itself. There are obligations that exist on parties that are implied obligations. So for example, you should not obstruct, as an owner, the contractor from performing their work. This is an implied obligation, so you should refrain from doing a negative activity, negative thing, such as obstructing the work of a contractor. So this is an implied obligation. It's not usually explicit in contracts, but sometimes the implied obligations by courts may imply obligations or may imply terms that's not just in the form of refraining from doing something negative, but also may go further into requesting the parties to perform certain positive acts. So it may instruct or may actually create an obligation that requires the owner to facilitate the work of the contractor rather than just refrain from obstructing the work of the contractor. Many contracts or many courts, when they're trying to employ terms, they actually think about or consider something called the duty to cooperate. In general, the rule here is that you should cooperate. The parties should be cooperative. However, this cooperation should not require any heavy business burdens. And in general, this basically cooperation is required if it assists the other party at minimal cost. So if you're basically making just a small cost, if you're just helping them out just a little bit, and this help is going to be essential for them to do their work if it's required, then basically it becomes more of a duty than if it was the case where it actually was going to be extremely inhibitive and costly. Examples of some of those implied promises or implied terms, the terms that could be implied by a court: the owner's promise to make a site ready for a contractor. If it's not explicit in the contract, that could be implied by the court, because it kind of makes sense. I mean, how could a contractor go ahead and build something without having access to a site? The prime contractor's promise to proper workmanship and materials. They're required to standards in the specifications. However, doing the right job is an implied is something that's an implied promise. It's not necessarily out there written in the contract, but in general it becomes implied. The owner's promise to basically that the design professional would basically act reasonably and expedite the contractor's work. So basically that the architect and engineer of record will basically work fast and produce the drawings and answer questions by the contractors as fast as possible. Okay, now, and the final thing is that many cases the laws employs a promise by the owner to supply adequate drawings and specifications. So if the drawings and specifications are faulty, extremely faulty, to the point that the work is hindered or inhibited, sometimes that could be a breaking of an implied promise in the contract, and may actually create a case of breach. Okay. So what are the sources of So we're now in this situation. The court needs to employ some terms to the contract. There is a gap that needs to be filled. So, for example, we forgot to mention when we are making payments to the contractor, which day of the month, which week of the month, and how often, for example, during a month. So one way that the court would go ahead and employ those terms is using custom. And generally, customary practice is an important determinant of how rights and determining the rights and duties of contracting parties, because this is how they've been doing business for such a long time, and therefore they basically kind of rely on things continuing as usual. And if there's a gap, then maybe it may be fair for us to assume that it's what they expected. So usually courts would emphasize on custom, specifically in process of contract interpretation or trying to employ contract terms, basically because it will consider it again to be the actual intention of the parties, because this is what they're used to. Contracting parties may be held to customs even though they don't know of. So let's say, for example, an owner new to an area, never done business with this particular contractor, and the contractor expects payment at the beginning of the month. The lack of awareness, because due to custom, this is the way everyone else does that in that particular region or market. So the lack of awareness of the owner does not basically create gives them kind of a right to not be held to that custom. They could be held to that particular custom, even though they did not know it. Or because they could possibly have known about it, or they should have known about it possibly also. Established customs are definitely more convenient methods for filling the gaps, simply because it's an expectation, it's well documented, people have been doing it, and usually can prove it easily with testimony, and it's not really a large leap from what people are used to do in the construction industry, so it's basically conforming to a norm. And customs in general can basically help interpret terms or conflicts in construction documents. So sometimes it's not just employing a term, so it's not like filling in a gap. Sometimes if there's even a conflict between documents, like between a specification and a drawing, or between writings in two separate areas of a general conditions of contract, or a discrepancy between the general conditions of contract and supplemental conditions. Basically, this custom can help interpret the terms or conflicts in the document, and can help provide the possible real intention of the contracting parties. But in general, don't rely on it. Just rely on try to get as much as possible written into the contract itself, to avoid any potential trouble. Now, another source. So let's say there's a gap, and the gap basically is handled by some building laws. In general, contracts do employ, or sometimes even state expressly, that the contractor will comply with all building codes and land use controls. So basically, whatever is required by code is an obligation on the contractor. In many cases, we have separate entities that are performing the design and the construction. Sometimes the designer is the one who made the mistake, or for example has violated the code. So in the case that design and construction is separate, design is the owner's responsibility for the most part. And the question you should ask there is, should the contractor build a design that violates a code? The answer basically to it is that the contractor should not ignore the law, and should direct the attention of the design professional to its violations. The AIA in the standard form of contract that we'll be looking at together does require the contractor to check for conformance with code and notify of violations. If the performed work is in violation, if they did the work in violation without notifying the architect, many cases they'll be held responsible. This is actually the language of the AIA contract itself. What happens if we don't have any direct clashes with building codes? If we have designs that don't have, they may have other troubles, they may have other problems, but in this particular case they do not conflict with any specific clause. So if there are no direct clashes with building codes, the contractor is basically expected to perform. Legal requirements and code requirements could be used in filling up gaps, and it's a good instrument for courts. As I mentioned, because it's just again very well documented. It's an obligation that it's very clear, and basically sometimes it's used for that and for having like workers comply with safety rules. So sometimes that's a way for courts again to put people in that corner. Other legal requirements for construction law perspective, from the legal side, include stuff such as building occupancy permits, permits to connect utilities, drainage and rights of way, permits from the state highway officials. So all of these types of permits exist and may be required for that specific contract, and the question is, who gets those, who buys those? Now, the general custom in this case, even though it may not be stated clearly in the contract, is that anything that's permanent and building related would be probably the owner's responsibility, because they get to use that building and they probably are responsible for paying for this permit. However, it could be expressed otherwise in a contract document, as long as it's expressed. But in general, also on the other hand, the contractor is usually responsible in that case where the owner is basically responsible for the permanent permits. The contractor will be responsible for the temporary ones. Like, for example, if you're closing off a road for doing a heavy lift, the owner really doesn't need to be bothered with that. It's usually a contractor's job to get clearances and permits for their work. But permanent permits would be usually an owner's requirement, an owner's responsibility. So as I mentioned, I just said that the construction documents usually will cover the matter that would say clearly. Customs again may allocate responsibility for permits as follows: owner would get the permanent permits; they would be required to do those, or the contractor would be again required to do the operational permits, such as, for example, well, actually, this is actually a building permit itself, so like would be something operational, like getting an occupancy permit from the local municipality or building authority. In general, contractors who fail to comply with the requirements and obtain working permits, they basically to obtain a work permit or submit a plan, that basically does not affect their right to compensation. So basically, in general, if you can't get a work permit or submit a plan, that may not actually impact your right to recover compensation for work that has been performed. Another source for implying terms in a contract is something that we'll basically spend a bit of time on, which is what we call good faith and fair dealing. So that's something that it was not really a requirement in the past. Common law did not usually hold this obligation of good faith and fair dealing. The reason being that the common law used to look at the written contract as something that's sacred. It should be upheld at any cost, even though it may be reflective of bad faith on behalf of the parties. Sometimes there's also an inherent assumption that contracting parties are able to take care of themselves. And the term in itself, good faith, is kind of imprecise. So what would the court determine to be good faith and fair dealing is something that could be disputable. Um, Basically, starting the 20th, beginning of the mid 20th century, American law has changed significantly due to the influence of something called the UCC, which is the Uniform Commercial Code, and basically that influenced a lot the concept of or the covenant, basically, of good faith and fair dealing. Basically, a party is not expected to guarantee any party to expect to receive any benefits. So basically, if you go into a business venture, I can't guarantee you, if you're going into business with me, I can't guarantee you that you're going to make money. However, it's my responsibility to avoid deliberately preventing you from making money. So I basically don't go into a business venture in order for you to basically lose money, or for me to get you to lose money. Um, the application of this specific concept or doctrine sometimes is basically applied in those specific cases, the cases that we're going to talk about in the following points. First, when it basically it's used for recognizing implied terms. So, for example, an implied term is that you will not prevent me from making money. You will not sell my work or cut my work so that you can get it cheaper from someone else. There are also sometimes unspoken objectives of the contract. So sometimes they're not discussed openly, but they're basically going to be employed later. I'll just take a quick break and get back to you. Sorry for this interruption. So again, going back to the applications of the doctrine. So one important application is, as we know, is the recognition of any implied terms that would establish elemental fairness, and would basically establish good faith and fair dealings in the transactions. So if someone was basically acting in bad faith, then basically they can recognize, and the implied term would be basically would presume what the other party was expecting, and would basically create would give them that right. So if, for example, a party was trying to convince the other one to do something that would let them lose some money, then basically the implied term would basically, if this is acting in bad faith, the implied term would basically just remove that responsibility from that particular party, or basically would actually make it in such a way that they would not lose that much money. Basically, it would also help us in finding unspoken objectives of the contract that would create a situation where this parties would be acting in good faith and fair dealing. It basically, if there's also, again, if elemental fairness happens to be lacking, basically it will basically create the application will be basically to go ahead and make it such that the elemental fairness is established. In general, breaches of the covenant of good faith and fair dealing has been very much obvious. The applications of it and the breaches of it have been actually could be actually taken to an extreme in specific cases. Those include insurance policies, employment policies, any violation of public policy. Basically, could basically all of those could be used for, could be actually allow for even the implication of tort remedies, not just regular contractual remedies. There basically are a couple of examples again in your readings that I'll refer you to them again, of cases where again the application of good faith and fair dealing was basically needed. of this particular doctrine was needed. Uh, in general, bad faith could be illustrated by showing an intent for making a change, and usually, like, for example, if you can go in and try for example to get subcontractors to agree to get to work with you on a project, and then later on trying to convince the contractor to strike out a lot of their work. So, for example, like the work in one of those two cases here is like that. In general, good faith and fair dealing could also be illustrated by communication. For example, if you ever have a case where an architect is not certifying payment, they actually are required mostly by many forms of contract, standard forms of contract, to mention why they are, to state why they are not certifying payment, why they're not allowing the contractor to get paid. Another example also exists from standard form of contract, which again highlights the importance of communication. Communications between sureties and contractors, when specifically when the surety is being informed of a default. So basically, there has to be communication between the owner, the surety, and the contractor in case of default, just to make sure that the contractor is not caught off guard, being accused of default, and then having the surety work with them. The surety has to work with them and try to get them to probably encourage them to perform before they actually take action and take over the project or get someone else to continue on the work of the project. Good faith is also important to be established in any settlement process, because sometimes duress could be applied or used to avoid settlement. Prime contractors sometimes have are in the position to negotiate for their subcontractors, and they're expected to do that in good faith. Like, for example, if they're negotiating terms for themselves and for the subcontractors, they're expected to mind and observe the best interest of their subcontractors as well. Termination of a contractor by an owner, that also has to be done while observing the principles and the covenant of good faith in the settlement process. So if there's a settlement that's going to ensue after a termination process, that has to also happen in good faith. Unconscionability is another, it's one of the last resorts for courts to go ahead and start employing terms. Common law in general does allow contracting parties to decide their terms of the contract. However, some contract terms may actually be unfair, extremely unfair to some parties. So basically, the UCC, basically the Unified Commercial Code, broadened the doctrine of unconscionability. It was basically very restricted in the past in contract law cases. It created kind of an obligation of good faith and fair dealing, and it basically limits the conduct of the contracting party. It just doesn't allow them free range to do anything and to do anything to the others. The doctrine basically is rarely been used to invalidate clauses in construction cases. However, the possible cases where it would be applied is cases of exculpation or indemnification clauses. So if you have a case where you have a contractor that's trying, or an owner that's trying to get out of an important obligation by indemnifying them against the risks that ensue from this obligation, this could be considered to be unconscionable. For example, one case, this again, it's in your reading, where a subdivision owner in its purchase agreement said that the dispute resolution clause required arbitration, and that was kind of considered to be unconscionable because it prevented people from the right to go ahead and litigate. So that was considered to be, again, unfair to the weaker parties, because the weaker parties aren't able to access arbitrators or defend themselves in front of arbitrators. They probably however can access the legal system. The legal system is much cheaper and it's less inhibitive for them to go ahead and pursue a dispute there. It's likely that it's projected that this may actually start increasing like the invocation of this doctrine may actually increase as a result of the increase in contracts that are standard. Again, some of them are entered by way of adhesion. They aren't really negotiated, and therefore may require the creation of the use of this doctrine of unconscionability for the implication of contract terms. Okay, so I'll see you all on Wednesday. Again, I'm sorry this was a little bit late, and next time we'll basically cover chapter 5 and well, actually I'm lecture 5, so I'm gonna basically be posting that along, and you basically can go ahead and read the last chapter of your reading concerning contract interpretation. Thank you so much, and I'll see you all on Wednesday.